SwayamPrabha. Digital India. Educated India.
Well, students, this is Dr. Ajay Kumar Singh, Assistant Professor, Faculty of Law, BHU. This is my 19th lecture, and the topic of today's presentation is compensation to the victim of crime. So, in this lecture, we will try to understand the meaning of victim and the purpose of the compensation. And then after, I would like to highlight judicial contribution, role of Supreme Court in recognition of compensation, in recognizing compensatory jurisprudence. So, let us start with the meaning of victim. As you all might be knowing that section 2WA of the Code of Criminal Procedure Code talks about victim of crime. According to section 2WA of the Code of Criminal Procedure Code 1973, victim is a person who himself has suffered loss or the dependents of the victim who has suffered loss collectively. You see, by this amendment, two things which you need to remember: the person who himself is sufferer, the person against whom crime is committed, or dependent of the deceased has also been considered by the criminal justice system to provide financial assistance to the dependent of the victim of crime. Not only the sufferer who himself has suffered loss or has been injured, assaulted by the offender, but dependent of the deceased has also been covered, so that financial assistance can be provided to the victim of crime, to the dependent of the deceased. So, for this purpose, Indian Parliament in the year of 2008 has given a very wide definition of victim of crime, so that dependent of the deceased can also be compensated, and with this objective, victim of crime has got place in our criminal justice system, in our legal system. As you all might be knowing that there was one important committee. The name of committee is Malimat Committee 2003, and Malimat Committee 2003 recommended that victim of crime should be placed in our legal system, because Indian legal system, Indian criminal jurisprudence, or particularly Indian criminal justice system, has neglected victim of crime, has never emphasized the plight of victim of crime. On the other hand, Indian criminal justice system has always emphasized the rights of accused and remedies available to the accused under Indian criminal justice system. So, this committee, Malimat Committee, for the first time made recommendation that victim of crime should be put into the mainstream and should be the focal point of criminal justice system, so that victim of crime or dependent of victim of crime may be included in our criminal justice system. So, with that objective, Indian Parliament has made slight modification in this Criminal Procedure Code 1973. Malimat Committee emphasized that the ultimate purpose of justice is to repose confidence in justice delivery system, to maintain public confidence in justice delivery system, and victim of crime should be put into the center, and trial court must ensure that victim of crime or dependent of the victim of crime should be provided financial assistance irrespective of conclusion of trial or trial begins, or where offender is identified, offender is traced or not, victim of crime should be provided compensation. Means Parliament considered the gravity of the issue, and considering the gravity of that matter, Parliament for the first time introduced this concept under Indian legal system. So, what is the purpose of compensation? As you all might be knowing that the ultimate purpose of compensation is to rehabilitate the victim, to provide restorative justice, to provide an opportunity to dependent of the victim of crime so that they can get financial assistance from the state or from the accused. Two things which you all need to remember, that is, where offender is not identified or traced knowingly or unknowingly, even though victim or the dependent of the victim, they are entitled to get compensation from the state. It is the duty of district legal service authority or state legal service authority to inquire, to accept the complaint made by the aggrieved, made by the victim of crime, and DLSA, district legal service authority or state legal service authority, will have to provide compensation to the victim where offender is not identified or not traced. Where offender is identified, so in that case, trial court may compel him to provide financial assistance to the victim of crime or to the dependent. So, with this background, we will try to understand that two important provisions have been added in the year of 2008. The first important provision is section 357A, which talks about compensation scheme, and section 357B. So, you will have to have idea about inclusion of these two important provision in under Indian legal system, so that you can get entire information regarding compensation to the victim of crime. So, let us understand section 357A of the CRPC, which talks about compensation scheme shall be prepared by central government or state government to provide financial assistance to the victim of crime or to the dependent of victim of crime. So, the word shall has been used in the statute. The purpose behind using this word shall in the statute is to compel the authority, statutory obligation to make a scheme, to prepare a scheme for rehabilitation, for providing compensation to the victim of crime. So, that is why in legal parlance you all might be knowing that the word may and shall has a specific meaning. So, that is why this word has been used in this section 357A. So, government shall prepare a scheme, compensation scheme for the betterment of victim or dependent of the victim. Now, next question may arise that what would be the quantum of compensation, how quantum of compensation may be ascertained or may be determined. So, the sole criteria to determine to a certain quantum of compensation is to consider the injury or loss suffered by victim of crime, and as per medical report, as per injury report prepared by medical practitioner, prepared by doctor, and on the basis of FIR or complaint, district legal service authority or state legal service authority will consider the quantum of compensation. Considering the gravity of injury, considering the gravity of loss suffered by victim of crime, that these two competent bodies will have to decide quantum of compensation. So, as I said, quantum of punishment is always decided by district legal service authority as per medical report provided by medical practitioner, provided by doctor, and medical practitioner doctor has to prepare that report on the basis of injury, on the basis of loss suffered by victim of crime. So, if quantum of compensation is inadequate, aggrieved is not satisfied with the amount of compensation, then he or she can make appeal to the higher court, to the High Court or Supreme Court. He or she can challenge the legality of that order passed by the trial court, passed by these two authorities, alleging that the amount quantum of compensation is not adequate. So, here High Court or Supreme Court, after considering relevant factors, if they find that compensation is not adequate, then High Court or Supreme Court may enhance the amount of compensation. So, this is the remedy against compensation order where compensation order is inadequate and aggrieved is not satisfied. Now, next important question is whether district legal service authority or state legal service authority are bound to dispose of the complaint within prescribed time. You see, one significant provision which has been inserted in the year of 2008, that is, district legal service authority will have to complete its inquiry within 2 months. Within 2 months, it will not take time, and neither district legal service authority nor state legal service authority will take time. So, in order to provide speedy justice to victim of crime, this inquiry must be completed within 2 months from the date of receipt of complaint. So, once complaint is made to the authority, once FIR is lodged at the police station, with the help of that FIR or complaint, district legal service authority will have to complete its inquiry within 2 months. After the completion of that inquiry, district legal service authority will provide compensation to the victim of crime. So, there is no exception. Neither DLSA can take exception nor SLSA can take any kind of plea that there was a reasonable delay or undue delay on the part of the authority. So, this obligation has been imposed by the statute upon the authority so that speedy justice can be done in the matter, so that speedy justice can be ensured. So, now let us understand with the help of this slide. I have prepared this slide so that you can get entire information. Victim of crime, section 2 WA CRPC. Now, next thing is compensation. Injury caused, loss suffered. On the basis of these two things, authority has to decide quantum of compensation. Now, you see this, the purpose of compensation is status quo ante, and status quo ante here means, as you all might be knowing, that there are two things, status quo and status quo ante. So, the purpose of compensation is status quo ante, to put the aggrieved in that position if he or she would have been, if his or her right would not have been violated. So, this is the purpose of status compensation, status quo ante. As you all might be knowing that right to life as a human right, as per UDHR, as per Article 3 of the Universal Declaration of Human Rights 1948, right to life as a human right. Every person has a right to live with human dignity. irrespective of caste, creed and religion, every human being has a right to live with human dignity. So, this right has been recognized as a human right under Article 3 of the UDHR 1948. Purpose is financial assistance to compensate irreparable loss. Parameter to determine compensation, as I have just explained, the parameter to determine compensation is the injury or loss suffered by the victim of crime is taken into consideration while deciding the quantum of compensation. So, there are two important parameters through which authority has to decide quantum of compensation. So, I have chosen this topic so that I can explain you law regarding compensation. You see, we have to see this entire scheme into three perspectives. The first thing is that constitutional provision. Constitution being supreme law of the land has to ensure justice to the victim of crime. So, for that purpose, we have two important provisions in our constitutional scheme under Article 32 and 226. As you might be knowing about Article 21 of the Indian Constitution, which talks about right to life. So, no person shall be deprived of his life or personal liberty except procedure established by law. So, this is specifically written under Article 21 of the Indian Constitution, that no person shall be deprived of his life or personal liberty except procedure established by law. Meaning thereby, any person can be deprived from his life or personal liberty with procedure established by law. So, even right to life is not absolute right. No one can claim this right in absolute sense. Even a person who has committed murder has no right to live in this holy world. His life he can be deprived from his precious right, he can be deprived from his precious right to life if that person has committed murder. So, as you all might be knowing that murderer has no right to live in this holy world, and because of that reason Article 21 specifically provides that no person shall be deprived of his life or personal liberty except procedure established by law. It means any person can be deprived from his life or personal liberty with procedure established by law. A person who has breached the law, a person who has committed murder has no right to live in this holy world. So, that is why punishment for murder is death sentence. Death penalty may be awarded to that murderer, to that criminal. So, in the light of that constitutional provision, you will have to understand right to life as a human right. So, where it is specifically provided that anyone can move before the High Court or before the Supreme Court for the enforcement of fundamental right or supreme right or Supreme Court, it is specifically provided under Article 32 that anyone can move before the Supreme Court for the enforcement of his right or her right where his or her fundamental right has been violated. So, Article 32 clause 1 talks about right to move, right to file a petition before High Court or Supreme Court in case of violation of fundamental right, that is itself a fundamental right. So, Supreme Court can issue any kind of order or direction or writs in the name of habeas corpus, mandamus, or you all might be knowing there are 5 writs. So, I do not want to emphasize that aspect of Article 32, you only need to understand that Article 21 and 32, these two important provisions are read together, and Supreme Court has already highlighted that right to life also include right to live with human dignity. So, second important aspect of compensation scheme is statutes passed by parliament or by state legislature. So, you will have to see what are other statutes enacted by the parliament or state legislature for the benefit of victim of crime. So, as you all might be knowing that state legislature can also make law for the victim of crime, and parliament has power to make law. So, you all need to understand that parliament has enacted special legislation for the betterment of victim of crime. I would like to refer to important legislation, the Protection of Women from Domestic Violence Act 2005 and the Protection of Women Act 1990. So, we will have to see compensation scheme in the light of statutory provision, and third important thing is that we will have to understand compensation scheme in the light of judicial pronouncement. How far Supreme Court has played important role in recognizing compensation, in providing compensation to the victim of crime. So, role of Supreme Court is very important, as you all might be knowing that Supreme Court has played important role in providing compensation to the victim of crime. So, let us understand one by one. Now, with the help of this slide, I would like to highlight constitutional provision pertaining to compensation to the victim of crime. You see Article 21, which talks about right to life as a fundamental right. So, Supreme Court for the first time held that even a rape victim is entitled to get compensation from the wrongdoer. So, the name of case is Bodhisattva Gautam versus Subhra Chakravarti, AIR 1996 Supreme Court. In that case, Supreme Court for the first time held that victim is entitled to get compensation from the wrongdoer. So, irrespective of the decision of the trial court, she is entitled to get compensation from the wrongdoer. It would be immaterial where trial is completed or not, matter is pending before the trial court. Irrespective of pendency of trial, pendency of case, she must be provided compensation by the wrongdoer. If wrongdoer is poor, if wrongdoer is not in position to provide compensation to the victim of crime, then it is the state liability, it is the responsibility of state to provide compensation to the victim of crime, because ultimately state is responsible to protect life and limb of its citizen. So, because of that reason, state will have to provide compensation to the victim of crime where offender is not in position to provide compensation to the victim of crime. Offender is poor, indigent, so then how he can be compelled? So, in that case, state will have to provide compensation to the victim of crime. So, with the help of this judicial pronouncement, you can justify, you can refer this case in favor of your argument. Now, next important thing is that statutory provisions regarding compensation. As I said, section 357 CRPC talks about compensation in criminal case. 358 CRPC also talks about compensation when a person is arrested groundlessly. 357A CRPC, it was inserted in the year of 2008. You see, compensation is considered as part of civil law, because many times you might have seen that criminal court, trial court has to impose fine in criminal case. So, fine and compensation, there is clear cut difference between fine and compensation, as you all might be knowing that fine goes to the government and compensation is given to the victim of crime. So, the third important thing is that, which you need to remember, that even fine may also include compensation, where court has impose fine with a special remark that this fine would go to the victim of crime, because this fine which court has imposed will go to the victim of crime. Then in that case, victim is entitled to get that part of that fine which court has imposed upon. So all these things you might be knowing that Supreme Court has held that even fine can also be given to the victim of crime in addition to the compensation. So you need to remember all these things. I will discuss the case laws where Supreme Court has categorically held this thing. So 358 CRPC is very least significant, you can say. Section 358 CRPC, which talks about compensation where a person is arrested without sufficient reason. So in that case, after acquittal means where that person is acquitted by the court, after having that acquittal order, that aggrieved can claim compensation against that person who maliciously or who had made complaint against that aggrieved. So the maximum amount which he can claim as a compensation is 1000 rupees. So can you imagine that when CRPC was enacted in the year of 1973, in 1973 the value of 1000 was so high, but now this part, you see, this thing has not been amended by the parliament till date. So nobody will take shelter of section 358 CRPC, because section 358 CRPC will not help that aggrieved adequately, because in section 358 it is specifically mentioned that where a person is arrested groundlessly, he can get compensation which shall not exceed rupees 1000. So maximum compensation which an aggrieved can get under section 358 CRPC, that is 1000 rupees. So nobody will take shelter of section 358 CRPC. So many times question is asked in examination, in competitive examination, that which of the following provision of the CRPC has lost its significance. So there will be 4 options, and section 3, you need to remember section 358, it has lost its significance because it is not, nobody will take help, nobody will invoke section 358 CRPC. Now come to section 357A CRPC, which talks about compensation scheme, which I have already highlighted, that where offender is identified, arrested, trial begins. Trial court may award compensation, interim compensation. You need to remember that unless case is finally disposed of by the trial court, compensation cannot be awarded by the court. So where matter is pending before the court, so trial court may award interim compensation to the victim of crime. This is the first situation. Second situation is where offender is not identified or traced, not arrested, where offender is absconded from the scene of crime. Then in that case, complaint or FIR, in both the cases, either aggrieved has 2 options, either he or she can make complaint or he or she can lodge FIR. So where offender is not identified or not traced, has absconded from the scene of crime, then in that case, aggrieved will have to make an application to the authority. Authority here means district legal service authority. That district legal service authority, after due inquiry, may award compensation to the victim of crime. Where offender is acquitted, you need to remember that acquittal will not affect the right of victim of crime. where offender is acquitted, even though victim of crime is entitled to get all the benefits which he or she can claim from the state. So here you see, you need to remember that where offender is acquitted, in that case it is the state responsibility to provide compensation to the victim of crime. Why state will provide compensation to the victim of crime? You all might be knowing that there is one important concept, that is parens patria. State is considered as parents of its subject. So state will have to provide financial assistance to the victim of crime where offender is acquitted. With that, this state liability, this liability lies in state because of that concept, that state is responsible to protect life and limb of its citizens. So where state has failed to protect life and limb of its citizen, it is the responsibility of state to provide financial assistance to the victim of crime. So you need to remember three important things. Section 357A has three important aspects which you all need to remember. Now, with the help of this slide, I would like to highlight another important scheme, that is known as CVCF scheme. CVCF scheme 2015, Central Victim Compensation Fund, CVCF 2015. As you might be aware about one incident which happened in the year of 2012 in Delhi, and after that incident, after Nirbhaya incident, as being a student, you all students might be aware about that incident. After Nirbhaya incident, central government decided to make special legislation for the betterment of rape victims. In order to provide financial assistance to rape victims, central government created a corpus of about 200 crores, that is popularly known as Nirbhaya Fund. So with the help of that fund, with the help of Nirbhaya Fund, rape victims, they are being provided financial assistance across the country. And this CVCF scheme 2015 talks about procedure to make application to the authority, how application shall be made, to whom application shall be made, by whom application, means who can make application to which authority. So all the procedures are prescribed in this scheme. The important thing which I would like to explain you, that is where application is made by a victim of crime to a magistrate or to a police. Victim of crime has two options: either he can make application, either he can make or she can make complaint to the magistrate, or he or she can make application to the police. So that application will be forwarded by SHO or by magistrate to District Legal Service Authority along with medical report. With the help of content of the complaint, with the help of FIR and medical report, District Legal Service Authority will provide compensation to the aggrieved. In case of death of the deceased, that FIR must be supported with postmortem report. So first information report, FIR, along with postmortem report shall be handed over to the SHO, and SHO will forward that application, that FIR along with charge sheet and postmortem report to the competent authority, to the District Legal Service Authority. And then District Legal Service Authority, with the help of that document, postmortem report, and FIR report, inquiry report, will decide quantum of compensation. As I have already highlighted, that where aggrieved is not satisfied with the quantum of compensation, aggrieved here means the dependent of the deceased. So, if they are not satisfied with the quantum of compensation, in that case they can make an appeal to the High Court or Supreme Court. This is alternative remedy available to the victim of crime. Now, come to this judicial contribution, how Supreme Court has played important role in providing compensation to the victim of crime. So, with the help of judicial pronouncement, we will try to understand the role of judiciary, particularly role of Supreme Court. The first case which I am going to discuss, that is Rudal Shah versus State of Bihar, AIR 1982 Supreme Court. PUDR versus State of Bihar, AIR 1987. With the help of this slide, you just look at this. With the help of this slide, I have selected 4 important case laws: Rudal Shah case, Nilavati Behra, PUDR case, and Chairman Railway Board versus Chandrima Das. So, with the help of these 4 important case laws, we will try to understand judicial contribution. The first case which I am going to refer, that is Rudal Shah versus State of Bihar, AIR 1982 Supreme Court. You see what happened in this case. Rudal Shah, he was to be released in 1968. He had been acquitted by the trial court in 1968, but due to negligence, he could not be released in 1968 and he had to remain in jail till 1982. He had to remain in jail for more than 14 years. And it was only because of negligence of jail authorities. Can you imagine that in our democracy, where jail authorities had failed to perform their duties, in this case Rudal Shah, he should have been released in 1968, but he had to remain in jail till 1982. 1980 means he remained in jail for more than 14 years. Considering the plight of aggrieved, Supreme Court for the first time held that state officials were negligent and state was held responsible. State of Bihar was directed by the Supreme Court to provide compensation to the victim of crime, compensation to the Rudal Shah. Rudal Shah, he had lost his precious time in jail, so that is why it is constitutional obligation of state to provide compensation to the victim of crime, and stern action should be taken against jail authorities who were involved in that incident. So, that is another aspect, punishment, suspension and punishment. That is, Supreme Court also directed in this case that government should take stern action against the wrongdoer, against jail authorities who did not comply the order of the court, who did not release him within time. So, 2 things which you need to remember in this Rudal Shah case. The first thing is that Supreme Court for the first time held that detainee has right to get compensation from the state where detention is illegal. So, in case of illegal detention, unlawful detention, detainee has right to get compensation from the state. This is one aspect of Rudal Shah case. In this case, Supreme Court for the first time evolved the doctrine of compensatory jurisprudence, that compensation shall be awarded where arrest is unlawful, where detention is illegal. First thing which you need to remember. Second important thing which you all need to remember, that is Supreme Court for the first time referred international instrument in this case, and that is International Covenant on Civil and Political Right 1966. That is, in brief, that is referred as ICCPR, International Covenant on Civil and Political Right 1966. In ICCPR, India is party to that international agreement. That ICCPR is a multilateral agreement among member states of United Nations organization. India too is party of that agreement. So India has expressed its international commitment to protect life and limb of its citizen. So Supreme Court also referred that international instrument in this case, that India is party to that international covenant. So it is the responsibility of Indian government as well as state government to express their international commitment, to fulfill their international commitment towards protection of human rights of the prisoners. To third important aspect of Rudal Shah case is that compensation. So why I have put this compensation on this third? Three important things which Supreme Court has laid down in this case. Detainee has right to get compensation. Second is state responsibility to provide compensation to the detainee, a person who has been illegally detained, unlawfully detained. And third importantly, that amount, quantum of compensation. So Supreme Court said that Rudal Shah was entitled to get compensation from the government, and government should award compensation to the Rudal Shah. So this is all about your Rudal Shah case. Second important case on this point is Nilavati Behra versus State of Odisha, AIR 1993 Supreme Court. In bracket, you see in bracket I have referred custodial death. So in brief, you can understand this. This is leading case on custodial death. Honorable Supreme Court for the first time recognized that right to get compensation from the government is a fundamental right, is essential component of Article 21 of the Indian Constitution. So where police officials are involved in custodial death, custodial torture, state concerned would be held responsible for the wrongful act of its representative. So where police officers who are acting on behalf of government, who are representing the government, they are the representative of the government state. So state would be held responsible for the wrongful act done by its officers, done by its representative. So having all these things in mind, Supreme Court for the first time held that where police atrocity, where custodial violence is committed by police officers, state government would be compelled to provide compensation to the dependent of the deceased. You see what happened in this case, in Nilavati Behra case. Nilavati Behra petitioner, she had lost her 16-year-old son, and her 16-year-old son was brutally killed in police lockup, and station head officer along with constable, they tried to convert that case into suicide case. So they had thrown out that body of 16-year-old boy on railway track, when Nilavati Behra made inquiry, when she made inquiry and she approached the police station, they refused to give information regarding whereabout of that child. Being aggrieved, she knocked the door of police authority. Even police authority, they didn't pay any heed on that issue. So she wrote a letter to a judge of Supreme Court. By highlighting all the incident in that letter, she wrote a letter to a judge of Supreme Court. That letter was accepted by Supreme Court, and that letter was accepted as a letter petition. And inquiry was conducted. A judge of High Court was directed to conduct inquiry. When inquiry was conducted, report was submitted in Supreme Court, and in that report, High Court, a judge of High Court, Odisha High Court, had revealed that it is a case of custodial death. So on the basis of that report, Supreme Court took cognizance, and Supreme Court held responsible all the police officers who were involved in that incident. Since Nilavati Behra had lost her 16-year-old son, state government was directed to provide compensation to Nilavati Behra, to the mother of deceased Nilavati Behra, and state government was directed to provide 1,50,000 rupees as a compensation. The important point is, even in 1993, statute was silent on this issue. We did not have a statute at that time which had a specific provision about dependent of victim of crime. So you see, in this case was decided by Supreme Court in 1993, and in that year, in 1993, we did not have a specific legislation regarding the dependent of the victim of crime. So Supreme Court for the first time recognized that even dependent of the deceased must be covered within meaning of victim of crime. So you see how Supreme Court started evolving concept of victim of crime in 1982 in Rudal Shah case. Then after in 1993, Supreme Court again widened the meaning of victim of crime, and ultimately in the year of 2003, Malimat Committee took cognizance over all these things. Malimat Committee did nothing, but Malimat Committee considered the judicial pronouncement, and Malimat Committee gathered the information with the help of this judicial pronouncement, and ultimately Malimat Committee recommended that victim of crime should also include the dependent of the victim of crime, dependent of the deceased. So that committee recommended only because of the judicial pronouncement, because in 1982 Supreme Court had already widened the scope of victim of crime. In 1993 in Nilavati Behra case, Supreme Court had already widened the meaning of victim of crime. Third important case on this point is PUDR versus State of Bihar, AIR 1987. You see, this case is PUDR, People's Union for Democratic Right, that is NGO, PUDR versus State of Bihar, AIR 1987. I have mentioned this case in this slide, and so that you can get entire information regarding compensatory jurisprudence. What happened in this case, in PUDR case? You see, as I have already highlighted the facts of this case in my previous lecture. Here I would like to highlight the facts of this case. What happened in this case, PUDR case? About 700 farmers, they were demanding their legal rights, democratic rights from the government, and there were in that demonstration there were women and children along with other farmers, they were demanding their democratic rights peacefully. Police officers who were present at that time, they did not give any information. Without prior information, they means superintendent of police, he gave order to fire on that mob. Though that mob was peaceful, the farmers, peasants, they were demanding their rights peacefully. And in that incident, about 30 farmers, including children and women, were killed by the police personnel. Since they were not in position, they were poor, they were not in position to fight their cases. The dependent of the deceased, they were poor, they were not in position to fight their case before the court of law. So this NGO PUDR decided to fight their case, and PUDR filed a petition in Supreme Court that government should be held responsible. Government as well as police officials should be held responsible for the wrongful act, because the police officers who were acting on behalf of the government had committed crime in eye of law. So that matter was taken into cognizance by the court, and Supreme Court took cognizance, accepted that plea petition, and Supreme Court held that all the deceased who were killed in that incident, the dependent of the deceased, were entitled to get compensation. Supreme Court held that all the dependents of the deceased are entitled to get compensation from the government. And state government of Bihar is bound to provide financial assistance to those dependents who had lost their relatives in that incident. And action should be taken against police officers who had committed that crime. Two important things. In this case, the irony of law is that state government took plea before the Supreme Court that this act should be considered as sovereign function. Sovereign function here means that act was committed by police officers in order to maintain law and order, and that action should be justified, but Supreme Court didn't accept the plea of the government, and Supreme Court said that maintaining law and order is sovereign function. Police officers, they are supposed to maintain law and order, but they cannot exceed their power which statute has conferred upon them. Here in this case, police officers, they had exceeded their power conferred by the statute. That is why they must be prosecuted and convicted for causing death by negligent act. They all should be prosecuted and convicted for killing of 35 farmers. So action should be taken. Supreme Court didn't accept that plea. And the fourth important case which you can see on your screen, that is Chairman Railway Board versus Chandrima Das. So in this case, Supreme Court has also recognized that where in this case railway personnel, employees, they had committed rape against Bangladeshi women, and since they were poor and this matter was brought into the notice of one lawyer of the Supreme Court, Chandrima Das, she filed a petition in Supreme Court by highlighting this issue. Government took a plea that foreigner cannot take protection of Article 21 of the Indian Constitution, but Supreme Court rejected the plea of government, and Supreme Court held that even foreigners are also entitled to get the protection of Article 21, right to life. Even foreigners are entitled to live with human dignity in this country. If they have come in this country, if they have arrived in this country, they are entitled to live with all human dignity as Indian citizen can. So, in this case, Supreme Court also directed the government to provide compensation to the victims against whom rape was committed. So, you see, I have covered each and every aspect of compensatory jurisprudence. I have covered each and every component of compensation scheme prepared by central government, statutes, role of Supreme Court in recognition of rights of the victim of crime. Supreme Court has, as I said, Supreme Court has played important role in protection of rights of victim of crime. So, I think I do believe that you all have understood the things which I have discussed in this lecture. So, with this I would like to conclude my lecture. Thank you all.
Hi, my name is Gillette Sam and I teach sociology at IIT Kanpur. One of the things you must have noticed if you read or if you talk to people around you is that they often refer to something called globalization, or they often say we live in a global world. What does this mean? Today I'll tell you about how to think about globalization or interpret the word global in a sociological manner. When sociologists refer to globalization, they refer to three things. The first is that that it involves transplanetary processes, which means that something is going on across multiple borders, right? The second is that it involves heightened liquidity and interconnected flows. Now, by liquidity, and this is a term that was coined by the sociologist Zygmunt Bauman, we refer to the increasing interconnectedness of things across the globe, but we also refer to increasing instability across the world, which means that potentially something that is occurring many kilometers away from you actually influences the place that you live in. So, if there is a natural disaster happening in one part of the world, maybe that causes people to migrate from that area and they come and settle where you stay. So, that is what we mean by liquidity. And of course, when we are talking about liquidity, we are talking about things that are really moving from one place to the other. Now, the third aspect, and this is something that you may not conventionally come across in the way people use globalization, is that of structures. So, let's take an example. Supposing I, as an Indian citizen, wish to visit a foreign country. Let's say I want to go to South Africa. Can I just pick up my bags and hop on the next plane and go to South Africa? Any logical person is going to say, no, wait, you need to have documents such as your passport or visa. Now, this passport or this visa is a representation of the larger structure that governs how people move across borders. So, we have things like border control, national security agencies that consider what kind of people are going to move from one place to the other, correct? So, when we think about globalization, an average person typically tends to think about things moving or people moving from place to place. As sociologists, we also consider that there are structures that facilitate or direct this movement across multiple borders.